Hello everyone. This is Dr. Souvik Roy, Professor and Associate Dean, School of Law and Justice, Adamas University. Well, we've already looked into offenses affecting life, and we understood the concept of murder, culpable homicide, what takes life, and how life is endangered, crimes, criminals, victimization, etc. From now on, the next few videos, we shall look into the aspect of offenses relating to body and reputation. Now, offences affecting body and reputation is very vital. This is also the module 4 of the substantive criminal law syllabus here on Indian Penal Code. And once we look into it, we realize that there are multiple offences that can be brought under the ambit of body and reputation. Needless to say, when you talk about reputation, you can talk about defamation, most importantly. And also, there is this aspect of criminal insult. However, the things that we're going to cover are hurt, grievous hurt. Then there is this concept of assault, force, and criminal force, very important. Then there is criminal intimidation, followed by wrongful restraint, confinement. And last but no the least, like I said, insult and defamation will come into the foray. It's very important for us to understand that we all human beings or subjects of the state have a bodily autonomy, the right to choice, the right to life, and which has been vested upon by our Indian Constitution itself. If you look into Article 21, yes, right to life is pretty much existent. However, these rights are not unfettered right, unabashed rights. These are rights, they are qualified with certain restrictions, which in Indian parlance, as per the law of the land, we call it reasonable restrictions under the Indian Constitution, Article 19. However, having said that, what is reasonable, what is unreasonable, often becomes a matter of question. And that's where, in crimes, in criminal law, and specifically so, what we're discussing here, substantive penal laws, there is a question of law and there's a question of fact. And it's the amalgamation of the question of law and question of fact put together what makes case fascinating, an idea interesting, and the interpretation of the law in the context of the same given facts from two sides, the prosecution and the defense, makes it a very interesting battle. On that note, let's get into the module. As I told you, it starts with hurt and grievous hurt. Section wise, although hurt and grievous hurt do come at the very beginning, however, I will touch base a little bit with what is going to come next in the next videos before we move into hurt and grievous hurt. Remember when we try to hit someone, or punch someone, or slap someone, the intention is to cause hurt. The intention is to cause hurt, and rightly so. Having said that, it is also important for us to understand just because our intention is to cause hurt, we might not be necessarily be successful in causing that. And if we are successful, it will be case of hurt. And if you're unsuccessful, it will be a case of attempt to commit a hurt. Very interesting, very fascinating. Now, the moment you say I made an attempt to commit hurt, um, what does that attempt look like? So somebody is standing in front of you, and you are this person. So you are the alleged perpetrator or the offender. This person will be the alleged victim. So this person will be slapping him. So here the slap comes. It's coming on the way, and it touches, and this person gets hurt. Pretty much within the framework of law. However, this concept of coming towards and being successful, or somebody stops and you fall short of hitting that person, there are two different things. Now, when you're trying and causing a reasonable apprehension in the mind of the other person that I'm about to use force, it is called assault. And once you use it, it is called criminal force. And once criminal force has been applied, my friend, let me also tell you what follows next is the idea or the concept of hurt or grievous hurt, depending upon the intensity of the crime, depending on the gravity of the incident, depending on the amount of force, the impact or the damage because of that impact of the force that has been caused. So clearly, although the framers of the code of the law has put the provisions in a certain order in terms of sections, but by now you are clear that how one intermingles with the two. Now, before we start with hurt, it's very important to understand in penal laws, hurt and grievous hurt has been put forth in two different parlance, and rightly so. Hurt is something of pain, disease, or infirmity. I repeat and I reiterate. Now, here I have with me the Bare Act in hand, and for reference, for understanding of the provisions, the sections, etc. If you look into section 319, 319 of the code, it talks about whoever causes bodily pain, disease, or infirmity to any person is said to commit hurt. Now, if you look into the first word of the section, whoever. Now, many a times, what we make a mistake, where we make a mistake is we tend to think that whoever is just a mere word. How does it matter? Like, there is not much importance laid on this word called whoever. Although in English grammatical context or grammatical scenario, or by going by grammar, whoever would mean whoever. It can be anyone. It can be an Indian national, it can be a foreign national, it can be a male, it can be a female, etc., etc., or the third gender for that matter. Basically, a subject of the state. Now, in this case, whoever would ideally mean the alleged offender, the alleged perpetrator, because whoever is the person who is trying to commit the crime of hurt here. I repeat, whoever in this context is the person who is trying to commit hurt. Now, that person could be a man, woman, can be from any religion, region, gender, etc. Foreign national who's here in India is governed by the Indian law as per the international laws, etc. And therefore, law of the land as well. So, there is a protection that the state or the Union of India, the country, provides. And subsequently, that's a right, and there is a corresponding duty to abide by the law. So therefore, under the circumstance that who is the alleged offender in this particular case, what he does is he causes bodily pain, disease, or infirmity to any person, and that is good enough to bring this under a case of hurt. Now, immediately, if we move to 320, section 320, it talks about grievous hurt. Now, let me tell you, 320 under grievous hurt is further segregated into multiple sub provisions, or there are multiple parameters which can be said to be, or it qualifies to be a case of grievous hurt. We shall come to that in a bit. Now, understanding that this element of hurt, the framers of the code, the drafters, put forth long back. like a long, long back, that the difference between hurt and grievous hurt, it's a form of an illustration. It is nothing binding per se. So, for our understanding, for a better clarity, it is a nice illustration to take the discussion forward, and it was correctly pointed out by the drafters as well, which I am reiterating current right now. So, in this case, let me tell you, when it comes to hurt and grievous hurt, the difference between hurt and grievous hurt is that the difference between a scratch and a wound. Very interestingly, a made point. The difference between hurt and grievous hurt is predominantly the difference between a scratch and a wound. Now, the whole point here is uh, this is a very nice example to lucidly elucidate the understanding of substantive penal laws pertaining to crimes, definition of crimes, and most importantly, punishment as well. Now, why do I say that? So, I say that because, say, for instance, somebody scratches you, there is hurt that has been caused, and you feel the pain. But, say, for instance, somebody comes with a sharp edged knife and digs a hole into your hand. You're not died, you're not dead either. And most importantly, over and above that, for me, uh, you're alive, but however, it has kept a very deep wound with blood oozing out. In the first case, somebody came and scratched with a nail. Now, from a purely common sense and layman's perspective, if we look at it, and just sheer understanding of human and its interaction with pain or physical bodily pain, let me tell you, a scratch will not cause that much of a pain as much. In the second proposition, somebody would come with a knife and dig a hole into a person's body would happen. When the blood is coming out, clearly it is more painful. So, therefore, one thing for sure you understood by now, that first one is a case of hurt, or in legal parlance, we call it simple hurt. And the second one, we call it grievous hurt, because the depth of the injury, the wound, is much more deep, much more grave, and much more painstaking for that matter. Now, clearly, as you can understand, when punishments are given, always remember, the greater the gravity of the crime, the higher the quantum of the punishment. That's a part of sentencing. So, if, like, outraging modesty of a woman, insulting modesty of a woman, and rape. Now, there are three distinct offenses and offenses targeted towards women here, not going into the debate of male rape and other, etc., etc. So, insulting modesty is what? Gestures, obscenity. Outraging modesty is either assault or criminal force. And then there is element of rape, where there is this aspect of penetration. And none of them are consensual, without consent of the party or the victim here. Hence, excuse me, it is quite clearly evident that the punishment for rape is higher or highest amongst the three. The punishment for outraging modesty of a woman is slightly less, much lesser, not as much as rape, but definitely more than insulting modesty. And punishment for insulting modesty is the least compared to outraging modesty, compared to rape. Why? Simple. The gravity of the offense, the gravity of the crime, the intensity of the crime, that makes things what it is. Hence, keep the whole long story short and bringing back, what are the aspects of grievous hurt are we looking at? Since the perennial question is that of pain, disease, or infirmity, these are the three essential features or parameters or congruents that make hurt a criminal offense. So, say for instance, pain. Yeah, you hit someone, the person feels pain. You've hurt that person. But having said that, say for instance, two friends or two brothers or within the household, like, parents and their children, the guardian and the ward. Suddenly, one of the friend goes and says, "Why did you do this?" Hut. And there's this slap. You feel hurt. Then immediately the response is, did you feel hurt? Arey, wait. Let, uh, let me just hit you and make you understand if you feel hurt or not. And it's a friendly banter that is going on. So oftentimes when it is a banter and the repercussions are not that big, remember in exceptions to criminal offenses or crimes. Under section 95, there is something called de minimis non curat lex, which is to say, court will not take uh, cognizance of petty or trivial matters unless it's a serious one. Court will not take cognizance of. Excuse me. Now, under the circumstance, again, what becomes very fundamental? Yes, you hit someone, you have caused hurt because pain has been caused, but you have done that with a very basic intention of the mens rea. Mens rea is guilty mind in the eyes of law to cause that hurt. You've successfully caused that hurt by mens rea. I again repeat the word and reiterate. It's a Latin word which means guilty mind. Disease. Now one must be wondering that, how can you hurt someone with a disease? Because the colloquial understanding of the word hurt in a very conversational English language perspective is something has to give pain and therefore it's hurt, and which is correct. No two ways about that. That is applicable here in the penal laws as well. No denying. However, all said and done, let me also tell you when you talk of disease, you're talking about something more specific than just being a mere hurt, pain caused, a slap, or a punch, or a blow. It's beyond that. So, say for instance, sexually transmitted diseases, STDs, are a form of hurt, and which comes under the ambit of disease. And the person who possesses that and is aware of that, please remember, possessing is one thing and being aware of it is another thing. They're two different parameters or points. So, in this case, the person who is suffering from a STD and at the same time, excuse me, who is also aware of the fact that she or he is suffering from it. But despite suffering, she or he enters into a carnal inkling or a liaison with another individual. Now, once that happens, person who is suffering from STD is transmitting that particular disease to another person. Now, that also comes under the ambit of hurt. Most importantly, if it's life threatening, which it is, there can be this aspect of attempt to murder in the long run, or culpable homicide amounting to murder, section 299, read with 300, and 301 through 304, and 300 part A, B, 304 part A and B, the punishments as mentioned. But in this case, the element of disease or hurt does fall into that category. Now, taking this discussion further, there is something called infirmity. Now, if you look into the concept of infirmity, you cause uh, a certain kind of hurt to a person or an action that leads to a situation wherein the person gets informed by this entire situation and is so grossly hurt that this person is not able to move or a permanent damage of sorts, etc. Now, when you toggle around with these three ideas, you get the basic concept of what hurt is. Now, as you take it forward from 319 to 320, you realize that 320 or section 320, Grievous Hurt, is further put into a more range category, much more specific outlined categories, which I shall look into right now. Well, 320, there are 8 pointers in that, or sub-laws, which parameters, which falls under the category of grievous hurt. First is emasculation. Second, permanent privation of sight of the eye. Thirdly, uh, again, permanent privation of the hearing of the ear. Then there is this fourthly, of a member of joint. Fifthly, destruction of permanent impairing powers of members of the joint. Sixthly, the sixth point that is, permanent disfiguration of the head or the face. Seventh is dislocation of bone or tooth. And eighthly is something to do with a person whose hurt is endangered with life or for a period of 20 days in severe bodily pain and unable to do ordinary pursuits. We'll come to that later. Um, let's take one at a time. If you take one at a time, you'll realize that the first understanding is that of emasculation, then eye, then ear. Well, it is not any kind of a rocket science, it's very simple and easily understandable. Now, if you cause a damage to the sexual well being of a person, wherein the person is chopped off or made devoid of her or his sexual prowess or prowess to procreate, and the damage is not necessarily a permanent one in most cases, unless, of course, there are ways to bring it back into the realm. This is a form of punishment, emasculation, that we see it's prevalent in some of the Middle Eastern countries as well. And rightly so, any kind of hurt or a greater form of hurt, which we call as grievous hurt, done, uh, which leads to emasculation, is something that is definitely falls under the ambit of section 320, which is to say, it is a case of grievous hurt. Next, you find the next 2 pointers: permanent damage to eye, permanent damage to the ear, and then privation of or privation of a member or joint. Now, eyes and ears are vital part of the body and vital organs, which leads to sustainability of important factors. Now, under the circumstance, uh, let's be very honest about it. Without eyesight, um, half the life, or if not, the entire life becomes dark. So, how important it is when you target someone's eye and takes off the power of that eye, and that person is not able to view, see anything. Next in line is ears. So, if you can't hear, that's again something very dangerous. Clearly goes without saying that as a result of which it is taken into consideration as grievous hurt, and rightly so. If you look into the fourth point, provision of any member or joint. Yes, you're talking about the limbs, you're talking about the bones, you're talking about your physical body, wherein it functioning within a system, and it functions within a system in a way that, the person's ability to maybe to move, to perform a particular function, to write, to type, to eat, to drink, somewhere the hurt has been caused in such a way that prevention has happened. The person has been stopped because of that damage, the injury caused. So, say for instance, a footballer plays football, suffers from a hamstring injury. Now he's unable to play. Now, this unable to play or the lack of ability to play because the hamstring or the femur bone has been fractured or the hamstring injury has taken place. So, it's an important joint or a member body which gets affected badly. So, no person has the right to cause such kind of suffering to another person. Now, taking that further, if we look into the aspect of the fifthly, destruction or permanent impairing of powers of any members or joint. It is kind of corollary to the fourth point, section 320, like we are discussing. And it further just reinstates and further just claims how important bodily functioning is, how important the entire uh, physical structure is when it comes to um, functioning of a human being at large. And anything which impairs, which damages, which abrogates the person from using it in a way that person should ideally use and should be able to use in a very natural way of life, a natural course of life, that will come under the ambit of grievous hurt, under either fourthly or fifthly, depending on the nature of the injury. Then sixthly, of course, permanent disfiguration of head or face. Now, when you talk about head or face, again, mm, face is the mirror of your being, oftentimes it's said, and it is the most vital part of the body in certain ways, wherein the representation of one's bodily autonomy is represented through the two eyes, ears, a pair of ears, and nose, etc. And any kind of destruction or permanent impairing, very important, there is this element of destruction on one side as per the law, simply, and then permanent disfiguration. So if it is a permanent one, like say for instance acid attack, which is of course an offense in itself now, mm, but if it has been thrown or done to the face of someone and it leads to disfiguration, that will automatically come under grievous hurt under the clause 6. Not only that, but also it is equally true that when it comes to acid attack, the separate provision pertinent to the same will be attracted as well, and multiple provisions will come into the picture along with criminal force and force, etc. Seventhly, fracture or dislocation of a bone or tooth. This is a no-brainer and very well understood. Why so? Because permanent fracture of a bone or a tooth is something that nobody expects and nobody wants in their lives. But that's besides the point. There are certain nitty-gritties to it as per the cases, the illustrations. So, in that case, let me tell you, if somebody punches, it caused pain, hurt, fine. Now, the punch has happened here. There's a hurt that is there, then suddenly one of the tooth becomes loose, and the other tooth came out. Now it becomes tricky that there are two tooths that are affected, teeth, Hurt has happened because the punch is here, it has caused pain, hurt is done. Now, as per 7, if fracture or dislocation of a bone or a tooth, in this case, we're talking about tooth here, more specifically so. Let me tell you, when it comes to tooth, mere loosening of tooth is not a fracture, as per the interpretation laid down by the Honorable Court from time to time. However, if the tooth becomes loose to the point it has come out of the joint, then in that case, yes, it can be a subject matter of injury and grievous hurt, because that will be a subject matter of fracture. And here the word used is fracture or dislocation. You hit someone with a bat at the elbow, and the bones of the elbow gets dislocated. It gets displaced from one place to the other. It is a serious one. Therefore, it will come under grievous hurt and not just simple hurt. So this is what it predominantly talks about, looks into, and trying to say. That is the clause. Seventhly, further we move to the final aspect. Any hurt, eighthly under 320, which endangers life or which cause the sufferer to be during a space of 20 days in severe bodily pain or unable to follow his ordinary pursuits, is often termed as grievous hurt, therefore. Now, there is a very interesting section or provision of this particular section, this, because this has led to a lot of arguments, a lot of misunderstandings, etc. That, listen to it very carefully. Any hurt, so it can be any kind of hurt, which endangers life. Now, this is the first part of the clause. Any hurt which endangers life, which means any hurt that puts the life into danger. Now, when you say any hurt that puts the life into danger, my friend, you are saying it's a case of grievous hurt. Well understood. Somebody punches here on my left. Of course, it will come out differently as a lateral inversion. Now, once it happens here, we all know that this is a vital part of the body where the heart is there. Or somebody strikes you hard in the lower abdomen. You know that this is that part of the body or the vital part of the body. If it gets hurt in a wrong manner, in a wrong way, with a adequate or more than adequate intensity or force, it may lead to losing or loss of life. So that is endangering someone's life, putting that person's life to a threat, to a danger of paramount dangers, to put it in a very simple term. Now, or which causes the sufferer during the space of 20 days, the second part it starts from here, or which causes the sufferer during the space of 20 days in severe bodily pain. So the person who is on the receiving end got that pack of punch here or the lower abdomen, wherever. Now, that person in a span of 20 days, repeat, I reiterate, is in severe bodily pain. This is the second part of clause 18. But it talks about a period, and the period here is 20-day period. Then it ends, not ends, there is a comma after bodily pain or unable to follow his ordinary pursuits. Now, if we look into section 320 clause 8ly, is segregated into two parts. One is, first one, I told you, endangering life. Now, the second part is to do with this 20 days. The second part is revolving around this aspect of 20 days. Please understand. And this 20 days, it says, which causes sufferer to be during a space of 20 days in severe bodily pain, comma, or unable to follow his ordinary pursuits. This becomes very important. Or unable to follow his ordinary pursuits. Now, let me tell you, will the 20 days be applicable only to the first half? Or the 20 days will be applicable that the sufferer to be during a space of 20 days in severe bodily pain, or during the space of same 20 days unable to follow ordinary pursuits? Is the interpretation like this? Or the interpretation is such that the 20 days is applicable for severe bodily pain only, and then there is a separate, different interpretation for unable to follow ordinary pursuits. Now, if you really logically think, of course, if I talk about playing football, somebody gets hurt, then clearly the concept of voluntary non-fit injuria will come into picture, and there is consent that is given. It's a sport, there is physical contact, and the defense will come into the picture. But if a person has kicked someone and that person was in pain for one day, from the second day onwards, the pain started subsiding and started doing the regular work. Will it come under the ambit of hurt or grievous hurt? Kicking someone is definitely not a case here that of endangering life. It is not emasculation, not ear, not eye, not head, face, discoloration, joint not broken, no member of or the point of the body is being impaired, nothing. But the person was kicked so hard that for good 16 to 20 hours is in severe pain, could not do any activity and resumed activity from day two. That is one. The other part of the story is someone takes a hockey stick and hits the person very hard on the leg, and the person cannot move or remains bedridden for a period of, say, what, 20 days. Then what happens? Then what happens? Here is the most important part. In legal parlance, we have this concept of ejusdem generis, of the same class and kind. And that is a principle in jurisprudence that is to be looked into. The name of the case I will mention, Abdul Sajid Abdul Sadiq versus State of Maharashtra. In this instant case, let me tell you, the Honorable Court looked into the interpretation of Section 320, that is Grievous Hurt, and the eighthly point, eighthly, which is divided into two parts. One is endangering life, and then there is a second part which talks about 20 days. And that 20 days is further segregated into that the sufferer during that span of 20 days in severe bodily pain, unable to follow ordinary pursuits. So they said that, the comma, that in severe bodily pain, comma, or that comma is to be ignored. The interpretation of the law, the language of provision, and the punctuation mark in English connotation or grammar, the comma is to be ignored or taken out or lifted out by using the method or the interpretation of ejusdem generis principle, and understanding it from the context of the uh, basic understanding of objective viewpoint of the framers who drafted the law, or the sentiment of the legislature while drafting it, and understanding things in that context, that 20 days is applicable for both, one for a period of 20 days in severe bodily pain, or for a period of 20 days unable to follow ordinary pursuits. However, having said that, which is the way the law of the land is, and that's the way it has been interpreted, and that's the way it remains to be there, all said and done, the loophole of the law is if somebody is, say, for instance, in severe bodily pain for 19 days, 23 hours, 59 minutes, or for that matter, unable to follow ordinary pursuits for 19 days, on the 20th day he becomes fine, doctor gives a prescription that, you're fine, you're good to go. So, how do you interpret a situation or a case in such an event? Well, we'll continue with that discussion and debate of hurt, grievous hurt, and this element of 20 days under 328 in the next video session. Thank you.